Good afternoon, Your Honors. May it please the Court, Brennan Wingirter on behalf of Lewis Frazier. May I reserve 3 minutes for rebuttal?
Yes.
Thank you. Your Honors, this is a sentencing-only appeal out of Giles County where Mr. Frazier pled guilty to 1 count of attempted aggravated sexual battery, which was a C felony. He was a range 1 offender, so he was eligible for probation, and he was facing a sentence between 3 and 6 years. The standard of review, of course, is abuse of discretion. I recognize that we're under bias, but we're asking this court to reverse the judgment because of the way the trial court arrived at its sentence.
You're not going to be happy until they do away with that line that says the misapplication of 1 enhancement
That's
factor.
correct, Your Honor.
Okay. I just want to make sure we're all on the same page
on the same
here.
page.
You are not going to be happy until they do away with that line.
Or the opinion altogether. That's correct.
Okay, that's fine. But because in all seriousness, that's where we are, right? I mean,
Correct.
I know you're going to make a much more in-depth argument, but at the end of the day, you're arguing that one enhancement factor was as far as the length of the sentence. I know you have
Correct.
the secondary argument, but as far as length of sentence is concerned, you got 1 misapplied enhancement factor. The law is extremely clear. The misapplication of 1 enhancement factor does not remove that presumption and the abuse and create abuse of discretion. So, I'm not saying you can't argue that. I'm not saying I'm not going to listen to that, but I would much rather hear about your alternative sentencing argument.
That's good, because that's what I prefer
Okay.
to talk about, Your Honor. I was going to say, unless the
I
court
figure you're just preserving the first one until they do away with it, which good luck, but
Yes.
I'd love to hear that other one, please.
Yes, unless there's specific questions on the enhancement factors, I did want to focus today on the manner of service and the total overall sentence that was imposed by the trial court. It was a 6-year sentence, which was the maximum, but for maybe more directly to purposes of today, the trial court denied any form of probation. And I believe that there are 3 ways or 3 types of errors that go into that, what the trial court did. Number 1, I think it appears from the record that the trial court confused or conflated probation eligibility with release eligibility. I think that the trial court did not recognize or certainly did not consider on the record the statutory presumption that a range 1 offender convicted of a Class C felony is presumed to be a favorable candidate for probation. And then finally, the trial court relied on what I think in the trial court's own words is fair to say were speculations about the place of Mr. Frazier's confinement and what might happen when he did become eligible for parole. I think the trial court said, I guess, based on your age and these things going on, you're probably going to get released, which obviously is never a guarantee. So those 3 things form the context behind the trial court's ruling. And so that's our problem with the court's ruling here today. I recognize it's within range, but...
No, let me ask you on that. So, and I'm not saying the trial court's right or wrong, but what precludes you, once this client has served his 30%, to say, hey, trial, go back. Your Honor, we'd like to modify because, it's clear from the transcript you were hoping this would happen. It has not happened. Can we look to suspend the remainder?
So unfortunately, I think that would be outside, unless we got really, really lucky on timing, we'd be outside the 120 days under Rule 35 by the time that happened. 30% of the 6 years is about 1 year and 9 months, I believe, if we're guessing. So he'd be outside the Rule 35 deadline, unfortunately.
Thanks.
So he is at the mercy of the Board of Parole at that point. But I think before we even get to that part of the analysis, if we take a step back and look at what the trial court said and in order of what it said, I think is important. So there were 2 different days of the sentencing hearing. They were about 3 days apart, I believe. At the first hearing, the trial court said, at the first sentencing hearing, the trial court said, so this is 100% to serve, correct? And the prosecutor incorrectly told the judge, yes, it's 100% to serve. The prosecutor then said, now that's if it is ordered to serve, but I do believe probation is on the table. So the prosecutor tried to clear that up at the front end. They come back for the second sentencing hearing, and the starts off by saying, so we're just here arguing about length, right? Prosecutor says, yes, length and manner. And then there's some more exchanges, and at one point the trial court says, I don't even think it's probatable anyway because there's a 30% to serve. So just to clarify, the percent to serve if confinement is ordered but because of the timing of the date of the offense in this case, it was pre that. So it was 30% to serve. The state did eventually clear that up at the sentencing hearing. So we all understood it was a 30% to serve if service was ordered, if confinement was ordered. It's not clear that the trial court understood that.
Well, isn't it clear from the later written order? And one of the things that's interesting to me about this case is we have what appears to be occurring in the sentencing hearing from your perspective, and I can see that. But we also have a written order that comes after that makes perfectly clear that the trial court understands that it's probatable. So what's the effect we should give to the written order, if anything?
To the extent it conflicts with the trial court statements on the transcript, there's a Tennessee Supreme Court
This is
decision.
State versus Brown, right? So, I mean, I think it's.
That the transcript, Crow is what I have, but Brown may say it as well.
So that's true. So we're to give no effect then to the written order as it goes?
As insofar as it conflicts with the transcript is what controls.
Okay. How does that also, this is taking you away from the argument just a little bit, but does that also apply with respect to the trial court's finding that the need to avoid depreciating the seriousness of the offense
Yes, Your
outweighs
Honor.
the other factors?
I believe so. And I think, to be fair to the trial court, and I didn't want to say that there's nothing in the record to support that, there is one line I cited in my brief where the trial court during the hearing said that I don't want to minimize the acts.
Sure.
That's the closest it came to saying avoid depreciating the seriousness of the offense. So I did want to acknowledge that.
Okay, so the principal thrust of the argument, though, is that the written order itself is essentially ineffective because it's directly contradicting what was said
Correct.
from the bench.
Correct, Your
by the
Honor.
court.
Yes, exactly. It is clear, and I noted also in the brief that the written sentencing order was prepared for entry by the DA's office. That happens all the time. We have party prepared orders. I'm not,
That
you know,
seems to be a
trying to.
less persuasive argument. to me.
Right. I'm not trying to take issue with that. I think the point is that it was not prepared by the trial court, and it does conflict with the trial court's
Okay.
verbal comments at the hearing, and the transcript does have to control in those instances. And so when you look at what the trial court was saying, I think it is a very fair reading that the trial court did not understand that just because something requires a certain percentage before you're released onto parole, or you're eligible to be released onto parole, that somehow makes you in on the front end. And frankly, we see this all the time. To that point, Your Honor, the only case, and I hope there's more out there that I've just missed, the only case I saw was Donovan from October of 2024 that two of Your Honors were on that case, where the court very clearly said, trial courts, you cannot consider release eligibility in your determination of the sentence. What we're seeing more and more of, and what I think happened here, is the court thinking that because there is 100% sentence or even a 30% to serve, that means that the crime or the offense is not eligible for probation. So we're asking the court to very clearly specify 4035-303 and 4035-501 are two different statutes, obviously. They have different considerations. And to that point, under the 303 part, what is statutorily ineligible for probation is not the crime that was being sentenced here. And so whatever the release eligibility was, whether it's 100, 30, 35, 85, whatever it is, that just doesn't matter as long as the eligibility for probation is established. And here, not only was there an eligibility for probation, but the statutory presumption in favor of probation. I understand that's still our burden as the defense to show that we should get probation, but I think it's pretty clear from this record the trial court never even considered that requirement, which it doesn't have to follow that suggestion in the statute, the presumption, but it does have to consider it. It is a required consideration.
So what's the remedy?
So here, I think in any case where we have a situation where the trial court, I wouldn't say here fails to put its findings on the record. I think it just put incorrect findings on the record, just misunderstood the law, and as I put in the brief, started in the wrong place.
Right.
And so I think two
There's
things.
nothing really for us to review as to whether probation is appropriate, because he didn't go through that analysis.
Well,
Correct.
I'm curious about that. Are you not arguing, are you conceding that the court followed the Trent factors and gave sufficient reasoning for that?
No, Your Honor. So I don't think the
'Cause
court.
I think that's what, I don't want to put words into Judge Dyer's mouth ever, but I wonder, I understood him to say, you know, it sounds to me like we're conceding that point. So are you conceding that the trial court properly applied Trent?
No, Your Honor. So there are two remedies, I think, that are available. One, whether the trial court applied the correct law or not, which our argument is it did not, or did not properly consider what it was required to consider before imposing confinement or probation. When that happens, this court can either remand for a new hearing or if the record is developed enough for this court to do a de novo review, it can. And we've asked either way
Well, it's-
in our brief.
Okay, but I will say this, and that's where I was going. It seems like to me, maybe because of the trial court's analysis, potentially some of that got short-circuited, which then narrows what we have before us as far as a fully developed record. So possibly the real remedy is just to send it back with the instruction, hey, here's what you need to look at, or here's what you need to say or not say. But,
Correct.
I don't know that based on your argument, if I am to agree with you, that I can really do a de novo review, because I don't know that it's really fleshed out. If your characterization of the record and what happened is accurate.
Absolutely, Your Honor. I think that's completely fair. If there is a remand with specific instructions to the trial court, 303 probation eligibility, 501 release eligibility are not the same thing. There is a statutory presumption for range 1 offenders convicted of Class C felonies. Here's the analysis. I mean, I hate that we have to go through that.
Is it a full sentencing hearing? Can the court articulate other factors than just the need to avoid depreciating the seriousness of the offense?
I think a remand, in all fairness, would be limited to manner of service, not to include length, if that's what you're...
Yeah, well, what I understood from the written order is that there was one factor that weighed in favor of a custodial sentence, and that was the need to
Correct.
avoid unduly depreciating the seriousness of the offense. If we send it back on remand, can the court make other findings that support that, or, for example, that deterrence would warrant it? That I understand there's not a history of criminal convictions, but there's a history of criminal behavior here, and that supports it too. Those findings weren't mentioned in the written order, and
Correct.
so in your view, the remand, does it open it up to additional findings?
I think so. And also then to include things like Mr. Frazier's health and all of the...
Mitigation or
all the
support
mitigate,
of.
correct. And unfortunately, there were not specific mitigation factors requested, but there was plenty of evidence and argument about what I would call mitigation in that sense. So yes, I think all of that would be on the table for the trial court on remand to consider. And to that point, I think some of just to get in a little bit to that third part about the inappropriate considerations about where Mr. Frazier would be confined and what that would look like for parole. What's interesting is that the trial court's comments in that regard seem to support, or at least cut against, denying probation. The court recognizes his age. He said, I believe the trial judge said, this is an individual who is in frail health. We recognize that. I very strongly recommend that he be sent to that special needs facility. The court then immediately recognized, of course, it had no authority to order TDOC to do that. The court then speculates, well, I guess you're going to get parole. Again, that's not within the trial court's purview. So on remand, I think the trial court should be instructed to limit its view to what we know are the proper factors to be considered in evaluating probation versus confinement. Taking all of that into consideration on that point.
So are you conceding we don't have enough in the record to do a de novo review?
I'm not, Your Honor, but I do acknowledge that because the trial court did not go through the correct factors, I can understand, based on this court's precedent, the preference is to remand and have the trial court make the appropriate findings in the first place.
What is in the record that we could look at for that if we did a de novo review?
So if there's a de novo review, the pre-sentence report is in there. There was a psychosexual risk assessment, which I will note. Mr. Frazier was found to be a low risk and a very low risk of reoffending. Those are things we talked about in the brief.
Psychosexual report is more complex than that, though, right?
Yes.
Because there are different risk analyses given to different tools that are used. And in some of those tools, he's rated at a moderate. I think there's one that is even a moderate to high risk, right?
That's correct,
So, I
Your
mean,
Honor.
it's a more complicated analysis than
Of
just
course.
saying he's a low risk.
That is correct. I'm referring only to the ultimate conclusion of that report, where they take all of those factors into consideration and say, based on all of this, we believe he's a low risk
I
or
think I read the
very low
report a
risk.
little differently. I think I read the report to say that under some tools that he's a low risk, but that under other tools he's not, and just trial court take that into consideration. But I'll defer to you.
And on that, I'll defer to the record on that, Your Honor. That is in the record. The entire psychosexual, the pre-sentence report is in there. There is plenty of testimony and argument, as I said, about his age, his health, triple bypass surgery, kidney surgery, those kinds of things. Of course, on the other side, there's the circumstances of the offense, the nature of the offense. The trial court did find the victim who testified to be credible. So all of that is in there as well. I do think that the court could do either de novo or remand, although I understand the court's preference is typically for a remand with instructions to the trial court on what are proper considerations and what are not proper considerations. And specifically in this case, starting with a presumption of probation, not it can't be probated because there's some sort of release eligibility on the back end. If there are no further questions, we'd ask the court to reverse and either remand or reduce the sentence, or excuse me, modify to probation if there is a de novo review. Thank you.
Thank you. General, what say you?
Good afternoon, Your Honors. May it please the court. Garrett Ward on behalf of the state. Your Honors, this court should affirm the sentence imposed by the Giles County Circuit Court here because the court acted within its discretion and advise, both in length and manner of service. Like my friend on the other side, I'll largely rely on my brief for length.
Let me ask you this.
Certainly.
I'm going to ask you the question that Judge Greenholz was talking about, and that is, and that she brought up, and that is, you have one thing said at the hearing, and you have an order that says some contradictory stuff. Where do we go?
So I think I would push back just a little bit at the characterization of the order as being sort of diametrically opposed or sort of strongly inconsistent.
Well, it's very clear in the order what the sentence is and how we got there, right?
Certainly, Your Honor.
I mean, I have not read in depth every sentence of the transcript, but I have read the pieces that y'all have laid out for us. There is some confusion, is there not, at the hearing?
Certainly, Your Honor. I'm not going to.
Okay.
I'm not going to.
The trial court does not make a specific
Right.
finding that the custodial sentence is warranted due to the need to avoid unduly depreciating the seriousness of the offense. I think you have to tease that out. And you're certainly not, and that's the only factor that's listed in the order. There are not additional findings that are made that were required, I guess, ostensibly by Trotter. Those findings aren't being made. You're having to tease that out of the hearing. And so on its face, it looks like we've got differing rationales.
I don't know that I'd say differing rationales. I think I believe it's pages 79 to 80, 81 are really the operative sentencing findings when it comes to whether this sentence will be served in incarceration. And what the trial court says, admittedly after some amount of confusion about parole eligibility and probation eligibility, the trial court says, essentially says, I'm concerned about sort of minimizing these acts. No, it's not saying exactly, I don't want to depreciate the seriousness of the offense.
That's what I'm saying. You have to tease it out.
I think
That there's just not a finding.
I don't know that I'd agree that there's not a finding. The court certainly doesn't say word for word what it later says in the order. I'd say the orders, if anything, is really clarifying what the trial court is saying at the sentencing hearing. If the trial court is saying at the sentencing hearing, I'm concerned about these acts being minimized, I think it's an entirely logical leap, or an entirely logical step to say, oh, the trial court there, maybe not in the most precise language,
Well, I guess
but
that's
it's
my
talking about
question.
depreciation.
And the question that Judge Greenholz asked on the other side, but it's my question now is, if the transcript says this, can we really take an order and say, oh, really what I meant, or really how I meant to say it was this, this, and this way, when the law is very clear that the transcript controls?
I think to the extent they're inconsistent, I absolutely don't. I take no issue with the sort of bevy of case law, whether it be Brown or Crow. I'm happy either way. That if the transcript is inconsistent with the order, the transcript controls. But I think here we're not quite to that level. We're more at, the order is certainly a little more precise, but I think the order is really just providing clarification on what the trial court says.
Well, here's why I think there's some confusion, perhaps. And let me see how this happens. When the trial court says we need to impose a sentence that's going to account for the harm that has occurred here, the trial court doesn't know, because the state didn't say, what offense he's pled to. So he's charged with, I think he was charged with continuous sexual abuse of a child.
That's correct.
Ultimately is pled down to attempted aggravated sexual battery.
Mm-hmm.
There's a wide range of acts that occurred here. She was 4 years old. She stopped it at 11 when she told him to stop. And it did. And that's one of the I think that's one of the reasons why enhancement factor 4 probably is misapplied, because we don't know on the offense itself whether her youthful age was in a position where she couldn't protect herself. Clearly she could at 11 because she did, but she couldn't at 4. But the plea agreement doesn't tell us, and the plea colloquy doesn't tell us when the conviction offense occurred. It's a no-low plea, so he's not admitting to anything as it goes. So when I'm looking at the need to avoid depreciating the seriousness of the offense, I'm trying to figure out what he's actually been convicted of. And I don't know. And so when I see, and I don't think the trial court does either, because it says it doesn't know. When it's analyzing the 4th factor, it says, I don't know what he's pled to.
That is certainly what the record says, Your Honor.
That's exactly right. And so when he says, I think we need to have a sentence that reflects this, I understood him to say, I'm taking into account prior criminal behavior. And the prior criminal behavior is a reason that I'm not going to countenance probation, because the prior didn't result in convictions, but prior criminal behavior clearly is here. But not under the circumstances of the offense, and not under the need to avoid unduly depreciating the seriousness of the offense. So when we say it's pretty clear what happened, I'm not sure that it's clear at all what happened, because the plea doesn't add elucidation. The parties didn't bring further clarity, and the court itself is confused about what it's doing. Don't we need a remand?
Your Honor, I understand your concerns, Judge Greenholz. I would not point to this sentencing hearing in any way as being sort of a parody of, a paragon of clarity in terms of what the trial court would sort of.
Or even what the conviction offense is. What are the facts that make up the conviction offense? It can't be everything over the course of a 6-7 year period. It can't be, given just the nature of the conviction offense. So what is it? And then how do we begin to sentence that? Taking into account prior criminal behavior, absolutely, but how do we begin to sentence this offense?
Your Honor, I understand your concerns. The hearing, at some point I have to just say the hearing is what it is.
That's fine.
The trial court does, I think, is sort of in the discussion, in some of the discussion of the offense by the prosecutor, I think there's some effort on the part of the prosecutor. I want to be clear that I'm not casting any stones at the prosecutor here. The prosecutor.
And none of us are. No. We're not casting any stone against the trial court or the prosecutor or anyone. It's just what we have in our record.
So I think the prosecutors take quite a few steps in this case to try to clear up several points of confusion that arrive during this hearing. She makes an effort to attempt to identify in my view, reading the entirety of the 2 sentencing hearing, undertakes an effort to identify for the trial court what the specific act is that is giving rise to this attempted aggravated sexual battery offense, and does, I'd say, successfully clear up for the trial court whether or not this offense can receive probation, whether or not the trial court has to order a sentence.
I'm sorry, Judge Dyer. Go ahead, please.
Well, I kind of want to get to the statements you're making there. And I know we talked about, yes, the prosecutor drew up the order, but the trial judge signed it. So there's nothing. That's it. He's adopted it. But at what point during the hearing, for instance, where you say the prosecutor is trying to clarify things, it also seems that she or he, whoever it was, could try all day. The trial court was just confused. And at what point do we all of a sudden just give grace to the trial court because the prosecutor did a great job of explaining it?
Your Honor,
does my question make sense to you?
Certainly, and I'm not advocating for some position where just abject confusion by a trial court can be cleared up by a statement by a prosecutor with no indication on the part of the trial court that it understood sort of that attempt to clarify. I would point to, at least specifically on the release eligibility point, the trial court, I think by the end of this hearing, makes some statements that indicates it does understand that this sentence does not have to be served in incarceration. At one point, the trial court makes a comment initially suggesting that maybe this isn't a probatable sentence, and then the prosecutor immediately says, well, it's 30% to serve, but only if you order confinement. And then the court immediately says, obviously I'm going to order confinement. So I think it's entirely fair to read at least that statement, that the court is, if the court is saying, obviously I'm going to order confinement, I think it's fair to read that as the court understanding that confinement is something it has to order and not something that will happen just by operation of law. So I would say there's I think enough on that point to say the trial court did understand that. Judge Greenholt's getting back, perhaps specifically to your concerns about is there enough clarity, sort of prompting by the prosecutor where the trial court indicates it can understand and point to a specific act. I don't have sort of a single passage that I can point to on that facet.
Well, the prosecutor doesn't even clarify it either. I didn't see, at least in my review of the transcript, I didn't see where the prosecutor came in and said, Judge, enhancement factor 4 definitely applies because the plea offense was when she was 4 years old. Or conversely, Judge, we're not arguing factor 4 here because the conviction offenses happened when she was 11. And she clearly put a stop to it at that point. I don't have the prosecutor identifying any specific act. It's every act.
I mean, I think,
and it is. The conduct here is atrocious, to understate the case for emphasis even.
Mm-hmm.
But when we're sentencing on a specific offense, I can't even make sense about what happened.
I think perhaps my best answer here and whether or not it's good enough.
Shouldn't we just remand this? Don't we have to, isn't there too much confusion in the record?
If this court feels there's too much confusion in the record.
The state doesn't believe so, though?
I think we're perhaps just about close enough. I think
That's
the
okay.
state's
General, I'm not going to ask you
position
to
here-
concede.
Having stood behind that podium before, I'm going to make him not make you
I'm not
concede
going
the
to
point.
ask you to concede. Yeah.
So I think to at least attempt to offer an answer, I think when the prosecutor was sort of talking about the abuse of trust factor, there is at least clearly a delineation between these previous acts when she's 4. Our conduct isn't about that. So the prosecutor is at least talking about, for the act that is before the trial court by referencing, look, in the past she didn't stop this past abuse. That's why this factor applies. I think that is at least guiding the trial court to some of the later conduct and maybe.
That's not the final act. Yes. Something before that.
It's not, yes, the original acts aren't the the problem, or the final act isn't the problem, pardon me. But I think that's about the best we have in this record on clarity. The plea agreement is what it is. The plea colloquy is what it is, and the hearing is what it is. This court will review the record, and if it finds there's this amount of lack of confusion and wants to remand, the state would understand.
Okay.
If there are other questions, I'm happy to answer them, but otherwise I would ask that you affirm.
Thank you, General.
Thank you, General.
Absolutely, Your Honor.
You're really going to stand up for rebuttal?
Matt, I just can point the court to one part of the record, if I may, regarding the back and forth and the quote that my friend relied on. This is pages 79 and 80. It's volume 4, and this is the second day of the sentencing hearing. So I think I said this earlier, but just to be clear, the first day of the hearing is when the trial court thought it was 100% to serve. Prosecutor, to be fair, tries to clear it up, but probation is on the table. But the next time that comes up at the second sentencing hearing, the second day, the trial court's first thing was, we're only arguing length, right? Prosecutor again tries to say, yes, length and manner. Later that same day, the trial court says, I don't even think it could be probated anyway because I think there's a 30% to serve. State says yes, and I'll take a slight issue with the phrasing. The prosecutor didn't say it so clearly as, Judge, it's only 30%, only if you order confinement, but you can still order probation. Instead, what the prosecutor said was that it's 30% if ordered to serve, and the court says, well, yeah, obviously I'm gonna order that. I don't think that's a statement by the trial court, yes, obviously I understand I have a choice. It seems in context to me more like the court is saying, I've been saying all along I'm going to order confinement because I have to because there's a 30%. The because is in that
So
statement
since you
as well.
stood up, I get to ask you questions. 30%.
Feels nice, doesn't it?
Yeah. So I want to go back to, and I'm not saying this is the state's ultimate argument, but in their argument there was, hey, look, the prosecutor tried to clean this up. Okay. So if the prosecutor had said, Your Honor, it's 30% to serve if you order confinement, and the judge says, oh yeah, you're right, I know that, and I'm going to order serve, is that enough?
No, because if the trial court would then also have to say, you're right, I understand that, but I'm going to order to serve because, not because there's 30% release eligibility, but because the need.
Well, yeah, but I'm just saying on that point, is that cleared up as far as he understood? That there's not a confusion of you have to serve this or I can order probation. It is, no, I get it. 30% is to serve, I get that.
That would have been
And
much.
then goes through his analysis of why he's ordering confinement.
Yes, Your Honor, that certainly would be much better than what we have here. And I see that I'm almost out of time, so if I could quickly on that point, looking at, in Donovan, this court said, we look at the context. And I think when you look at the context of this, the court didn't even understand split confinement, I think is clear from this. Because at one point, the court said, the court feels it cannot minimize the acts such that this would be only a probatable type sentence, which I don't even think it could be probated anyway, because I think there's a 30% to serve. That completely misses the option for split confinement as well. So we would, again, ask this court to reverse and remand for a new hearing with proper considerations. Thank you.
Thank you.
Thank you.
Thank you both.
Yeah, thank you both. Yeah.
Okay, call the next case, please.